is spot on, that many of us have waited. It's a very busy time when you have kids, understandable, but we certainly do hear that from people quite a lot, that they've been intending to do it for years. And I do think that it's a tremendous, weight off of people when they finally get those documents in place. So I'm happy. I did get lots of questions. I tried to integrate as many of those into the presentation as possible. And so hopefully many of the questions that were submitted will be answered during my talk here. But I will look forward to the Q&A. And just to say, as part of our firm's consistent offerings, we always are happy to give a gratis introductory meeting that's 30 minutes long, where it is really specifically designed to answer people's questions. So I would welcome you to sign up for that if there's any questions that weren't answered, or if there's further inquiry that you'd like to make. So I'm going to go ahead and get started with the presentation. Contact information is here, but you can always Google our firm. We have recently had a firm change, a name change, as we are expanding. It used to just be called Laura Fischer Law, and now we are Fischer Harbage and Associates, but either one will get you to us. So yeah, we will look forward to hearing from any of you that want to learn more. So just going to start with a general introduction here. We're going to start with the top 5 questions that we get asked here as trust and estates attorneys. First one is, I don't own a mansion in the rolling hills. Why do I need an estate plan? I think the use of the word estate often is fairly misleading for people. We all have an estate. Lots of us are scrimping and saving, just trying to get through these, years when our kids are younger. But nonetheless, we all do have an estate, whether you own real property, you have life insurance as your major asset, it's all considered an estate. And what an estate plan really is a plan that includes both practical information and the tools to effectuate some kind of a basic plan that would give your loved ones guidance about what to do if, God forbid, something happened to you. That in a general way, there's 2 aspects to estate planning that we really try to address. One is incapacity, meaning a person, is unable to make decisions for themselves. A spouse is not an automatic, does not have automatic legal authority to make those decisions. So there are documents that are very important to put in place for every family. A lot of us, when we think about doing our estate planning, we'll also think about our parents, and aging parents certainly can benefit from that type of planning as well, making sure that the documents are in place that would allow you to make decisions for your loved ones. So that's part 1, incapacity. Part 2 is planning for end of life. And usually an estate plan can be put together that's fairly simple, enduring, and can often be a one-time undertaking, that you can get a plan put in place now that would last throughout your lives. It would contemplate as what would happen as you age and what would happen as your children age. So that gives you a sense, and the practical pieces are really providing a basic, framework for letting somebody know where the documents are that address these things, how they can be utilized, and generally who one might contact, as well as where the assets are. So at my firm, when we do estate planning, it's not just a matter of putting the documents in place. It's really helping clients to develop a very robust and comprehensive plan so that everything is very clear, and what would obviously be a difficult situation for a family can be made a lot easier. With that in mind, I just want to discuss what an estate is. So I think, as I was mentioning, the estate is all the assets. And for many people, that means life insurance. When we're starting out with young children, it is not uncommon that the major asset that we see is life insurance. But as we go along in life, hopefully we are lucky enough to acquire other assets, some of which are real property is a deeded asset, whereas a retirement account has a beneficiary designation on it. So the idea is that certain assets must pass through a court process without particular planning in place. And I'm going to get into the very specific documents in just a few minutes. But I just wanted to present that to you, to think in terms of certain assets that pass by beneficiary designation and certain assets that pass according to a will or a trust if you make use of them. So I will get into that a little bit more in just a few minutes. So question number 2, why should I pay an attorney to do it instead of using a free online or cheaper service? So, oops, sorry. So I would say, there's a lot of people who would say it's better to do an online will than do no will. I'm a little mixed on that because honestly, what we see is, just this year, I asked my team to kind of look back and see how many clients had we gotten that had done online wills. So we've had over 15 clients since the start of the year that have come back to us to do their wills correctly, with an attorney, because there were erroneous things that were done in the will. We're going to talk a little bit about trusts in a few minutes because there's lots of different types of trusts. But that is, error number 3 is what, really usually brings people to us, that it's missing a trust, that they find out, oh, I'm supposed to have a trust because I have minor children and my will doesn't have one. The other thing is that every state has very specific requirements as to what must be included in a will. And often these online services do claim to be state specific, but they don't include the right affidavits or reference to the right statutes. And these types of things can be very costly and difficult to manage in a court proceeding after a person dies. The other thing I just want to point out is that the execution of the online documents can be very challenging for people. It is certainly required in New York that there be 2 witnesses present and that they sign a very particular affidavit. And the nice thing about having an attorney present for that, it's not required, but the nice thing about having an attorney present for the signing is that the attorney can validate that this was done properly, that the person was of sound mind and was stating that these were their wishes. And they also can direct the signing so that the right places can be signed, the right places can be notarized, things can happen seamlessly. And the attorney, if it ever were challenged, would be the first person to come back and acknowledge that the circumstances of the signing were correct. Probably number 4 is one of the most important reasons to consult with an attorney, because making the choices that are required for your will can be quite involved. Who to choose as a guardian? Should that guardian also be the trustee, the person that's in charge of the resources? Can 2 guardians be appointed? Can 2 trustees be appointed? Can an international person be appointed? These are all questions that we would walk you through, help you to decide if that's right for your family, and how to draft the documents appropriately so that all of those choices could be accommodated. So question number 3, what really happens if you don't do your planning? So a couple of things I want to address. I mean, there's lots of variations. Every family is different. Every situation is different. But the reality is, if somebody doesn't have a will in place and they have children and they were to die, any asset that they own or any asset that they jointly own that's titled so that it would split, half going to each spouse, their portion of it would pass half to their children and half to their spouse. Now, some of us are single parents, some of us are married, but for married people, I'm sure that that's not an ideal situation. I think most of us imagine that our spouse would continue to manage and own the assets. And if it passes to a minor child, there's an ancillary proceeding that has to happen called guardianship of the property. So it can be a messy situation where all of a sudden assets that you were owning with your spouse or partner are now passing directly to children who have no ability to control them. So you have to establish somebody who has authority for those. And also just that at some point you may be beholden to decisions that your children will be making about half of the asset that you probably felt was entirely yours. So there can be some pretty difficult circumstances that can befall a person without estate planning in place. The other obvious point, and the thing that I think is most near and dear to our hearts is thinking about guardianship of children. If a will has been put in place that appoints guardians for children, the process is relatively pro forma for seeing that appointment through. In other words, the courts in the United States really defer entirely to what people have in their wills. If there's a challenge raised, it's very difficult. The one thing, procedural thing, is just that there's a simple check to make sure that a person who's appointed doesn't appear on a child abuse registry. As long as that doesn't happen, the court will see that appointment through. Now, without a will in place, all of a sudden the court has to take responsibility for interviewing, validating, screening, and deciding who should be a guardian for a child. So this is an incredibly important aspect of putting a will in place. The difference between the proceeding that happens with a will, in other words, and one that happens intestate, a guardianship that happens through intestacy, meaning without a will, is vastly different. So I think that's a very important reason to do your planning when you have minor children. There's a lot of other reasons, but I think those are probably two of the most significant. Next question. Why do I need a trust? Isn't that only for wealthy people? So, and do I really need one? So I think there's a lot of misinformation about what a trust is out there, for starters. So trusts, there's many different types of trusts. They really run the gamut. But the first distinction in types of trusts is a trust that is part of a will and a trust that is a standalone trust that is often called a living trust. A trust that is in a will is just something that gets created when somebody signs a will. It creates an empty repository, a place where assets could be held and utilized for children's upbringing at a later date, meaning if something were to happen to somebody. A living trust, there's many different types of those. And when we think about our lucky friends who have trust funds and their parents have set up trust funds, or maybe their legacy trust funds, those are all different types of living trusts. But there are very simple types of living trusts called revocable living trusts. Those can be very useful in a basic estate plan. They are not essential. And I will happily give you all an overview of our packages and the prices at the end, just so that everybody can see, very clearly what they would be looking at in terms of proceeding with some planning. But our basic package does include that testamentary trust for the children. And the reason that a trust is so important is because a child under 18 cannot own assets unto themselves. So if something were to happen to somebody who has minor children, and say they have a life insurance policy where they've named children as their beneficiary after their spouse or partner, God forbid something happens to both parents and the primary asset, or at least something that, any of the assets, but let's just say the life insurance was bought to make sure that the children would be supported through their minor years. Now, if the children have been named as the beneficiaries on that life insurance policy, and a check were to issue to those children, that would have to be treated as an asset of the children. And basically the court would end up holding it until a child was 18. It could be only distributed under very limited circumstances, meaning that basically the guardian that would be appointed would have to show they don't have the financial resources, but that would then be distributed to the children at 18. Also a very catastrophic, idea that not only would the asset not be fully available for a child's upbringing, but also that a child would potentially be inundated with a level of wealth that they wouldn't be prepared for. So just to revisit that, with that basic package, we always include a child trust. That basic package costs $22.50 for a family. That's complete for both parents, both, or if people are not married, for a single family. But it is the comprehensive package, and it does include the trust and everything that you need. So we would talk more in depth about that in terms of what the benefits of the revocable living trust and the cost of that. But I'll also give you that information at the end of the presentation. Lastly, just to say, people often say, why should we work with you? So I just putting up a couple of our really wonderful reviews from other Park Slope parents and, lots of Brooklyn parents out there. If you, want to take a look at our website, a lot of those are there, or you can Google us and see a lot of our Google recommendations there. But I do think that we provide a very humanistic and compassionate experience, and also, obviously precise, accurate documents prepared with excellence, so that that everything would be taken care of if God forbid something happened. So let's get into talking a little bit about what an estate plan is. Let's talk about each one of those documents. So that basic package that I mentioned, that includes 4 documents: the last will and testament, power of attorney, healthcare proxy, and a designation of temporary or standby guardianship. The last will and testament, I think that's probably the piece that most people think about when they think about doing their planning. And that is where you would create the child trust. You would also make all of your gifts. You would say how you would want your assets to be distributed. And it's also the only place where you can appoint a permanent guardian. So incredibly important. The next 2 documents, power of attorney and healthcare proxy, these are the 2 documents that I was mentioning before that really address incapacity. Every person should have these in place. These are statutory, very straightforward documents. There's a number of elections that you need to make in these documents, but the documents themselves are standardized for New York, and they are what would give somebody else the authority to make decisions for you if you couldn't make decisions for yourself. Power of attorney for financial decisions, and the healthcare proxy for medical decisions. And then the designation of temporary or standby guardianship is a document that allows somebody to have immediate authority for children. If, God forbid something happens to somebody, it does take time for the court to act and make that permanent appointment of guardianship. So the temporary guardianship is the document, it's a statutory document that gives somebody the authority for children in the interim, for medical care, to interface with a school, anything like that would be needed. So we just kind of went through this slide. What does the last will and testament address, and why is it important? It addresses the gifts to loved ones, the appointments of loved ones that would take care of your kids, and the trustee. So the trustee, again, we talked about the trust that is part of the will, and the trustee is the person that's appointed in the will to manage those assets until a very particular age that you would choose, and at which point your children would, your child or children would begin to manage assets for themselves. And the incapacity documents, we touched on those as well, the power of attorney and the healthcare proxy. As I mentioned earlier on, it's always really important to make sure that all of our loved ones have this. And as part of your planning, you might think about addressing these things for aging parents, or even young parents. Even parents, if your parents are in good health, they always should have a power of attorney and a healthcare proxy in place. So happy to talk with you a little bit about succession planning, addressing parents' needs as well as your own with your own children. Yeah, and that leads to the next really important question. Why should you recommend that people that you care about do their estate planning? Well, ultimately, the reason we do our estate planning is to make sure that we are doing the responsible thing by the people that we love, because they're the ones that would have to deal with the mess if we don't do it. So for the same reason, we should encourage people that we love, like our parents, to do their planning, because when things happen without planning in place, difficult situations can be made that much more difficult. We do also do planning, just to give a little brief overview about Medicaid planning. That is a service that my firm does cover. Medicaid planning is a version of planning where for aging people that you put assets into a type of trust called an irrevocable trust, a non-revocable trust, and it shelters them so that people can qualify for Medicaid. I think we're probably all aware that, medical and health needs for our aging population can really deplete resources quickly. And what a Medicaid trust can do is shelter those assets so that those resources can be used for ancillary needs for aging parents, but not be eaten up by all the medical needs. Medicaid would step in and pay for the medical needs, in other words. So it can be a really wonderful way to preserve family wealth, Something that's definitely worth some inquiry. A lot of people don't necessarily realize that this is a version of planning that's possible, but something we certainly encourage. So, happy to talk more about that or send literature if anybody is interested in that. Next question, and this was one that a lot of people asked, how and when to start. So we really pride ourselves on making the process fairly seamless. I think our reviews reveal as much. I think you would feel very much informed and supported in your decision making. There's a number of reasons why people will come to us. Many people, like Dorothy said, they've had it on their to-do list for years. They're ready to get it off the list. They don't want to have that, that weight on them anymore. That's probably 70% of our clients have, come in saying. Other people, just certain people out there get very organized when they're pregnant, maybe part of the nesting experience, but we do work with lots of people before they have a baby to make sure that the documents are in place. And it's absolutely fine to do planning before a baby arrives. You can accommodate for all future children in the documents that we create. And then of course, aging parents, as we talked about, that's another big group of our clients that we work with, people that, want to make sure that their parents have the basic documents in place. And certainly then we do talk a bit about trusts, what some of the various trusts can offer. I do want to mention tax planning. It's probably a little bit much for us to get into, but I do want to touch on that basically just to explain what tax planning is. So the tax that we are concerned about is the estate tax. And the estate tax is based on the size of an estate. There is no income tax that's applied when gifts get given. There is no there's another term called inheritance tax, which is based on, degree of relation, et cetera. That is not in place anymore either. But there is an estate tax that there's a New York estate tax and there's a federal estate tax. They are both based on the valuation of an estate. There's a threshold that's set, and anything above that threshold is what gets exposed to estate tax. In New York, there is what's called the cliff, which means that if it surpasses the threshold sufficiently, the entire estate can be taxed. It's a hefty threshold right now. We're lucky that we have this opportunity to do some planning around it because the threshold for taxation on the federal level is almost $13 million. And the threshold in New York is about $6.5 million. So that means each person can have, an estate of that size before they're going to face an estate tax. And like I said, that, those numbers can change, but the idea is that we protect you so that, if your estate does surpass that level, that we can put trusts in place that would shelter those assets from the tax. It is a 40% tax on the federal level, so incredibly hefty. And New York is anywhere between 15 and 20% usually. So but if you do have a taxable estate, it is certainly worthwhile. There's some very simple devices, and then there's some very complex devices to manage an estate tax, but it is certainly something worth looking into. And that is the one tax that we talk about when we think about planning for an estate. Like I said, there is no income tax applied, and we would talk with you a little bit about capital gains taxes and how to preserve what's called a step up in basis, wherein your loved ones can actually be relieved of a capital gains tax. Capital gains meaning the income tax that's applied on the yield of a sale of an appreciated asset. But those are things that we would cover, in a basic, if you came on for a gratis consultation, happy to talk with you a little bit more about those as well. So yeah, just to say, our firm and how it works, we really pride ourselves on being a very compassionate firm and really connecting with our clients, making sure that they feel very much empowered, educated, and cared about. And we walk you through the process. Like I said, our process is very efficient. We do flat rate packages, so you will always have as many meetings with myself or members of my team here, whomever you would like, as many meetings as you need to feel like you have the tools to make sure that you're making the right decisions. That said, usually within a couple of meetings, people have their decisions made. We draft the documents for you. We do a review call where we take you through each of them, as many of calls as you need to make sure that everything makes sense to you, and then take you through basically reviewing all of your assets, making sure that all of those beneficiary designations are the way that you want them, making sure that the titling on assets is correct. If you have any ancillary agreements that impact your property, we are happy to review those as well as part of your plan. But it's a very comprehensive package in the sense that at the end of it, you'll know exactly how to explain to your loved ones how they would manage if something were ever to happen to you, whether that, were an incapacity event or you're just planning for the rest of your life. And like I said, for many people, one plan is sufficient. You can get your plan in place and know that it would last the duration of your lifetime and not have to revisit it. It usually can accommodate, most of life's changes, moving, more children, things like that. So that kind of gives you a sense. I'll just put my team up here. I work with an incredible group of women. Everybody is extremely knowledgeable, very hands-on, responsive, and deeply cares about our clients. We have been blessed with really wonderful clients. Just a little bit about me. I've been a trust and estates attorney for over 15 years. I started off doing a different kind of law, then had kids and changed my focus a little bit, but I've had this practice for 15 years. We are right here in Brooklyn. We also have offices in Manhattan. And yeah, so that gives you a sense. We are happy to meet with people here. Our office happens to be in Clinton Hill. The office in Manhattan is downtown. Here's a little bit about our packages. We like to put it right out there, the cost, so people are not under any illusion about what they're getting into in terms of an investment. As I mentioned, our basic package really does cover all of your needs. It really has every document in there. If you're Googling what should an estate package, contain, some of the, the terminology for it, healthcare proxy, for example, that's what we call it in New York. It includes a HIPAA release. It includes a directive about remains, things of that nature. Those things can have different names in different states. But these 4 documents are a very comprehensive package that really covers all of your needs. And that package is standardly priced at $22.50. We are offering a discount if you come on with us before August 1st. We're happy to do that package for $19.50. That is for the family. The revocable trust package that also, or tax planning packages, these packages are $44.50. They include all of the basic documents plus a revocable trust. Again, we've offered a discount for this, $41.50 if you come on before August 1st. If you needed to do tax planning with more, some of these irrevocable trusts that I kind of touched on in a general way, happy to provide a price list there. We do have a very fixed cost that is very clear, and all of them include as much counseling as you need. So we're right at 7:30, and almost to 7:30, and I did want to just kind of touch on some of the questions and make sure that I've covered most of them. Single parents, I would say we do service a lot of single parents. That's a very important time to do planning. As a single parent, it becomes even more important that you have the structures in place that if God forbid something happened to you, a child or children have a trust set up. Like I said, it can be part of the will or a standalone. These are things we would discuss. But that becomes an incredibly important question. Life insurance, we are happy to walk you through that process. It's not a service that we offer. We have trusted people that we are happy to refer to, that we have no financial relationship with, just other people like us who have a very, who get very positive responses from from our clients about their work with them that aren't heavy-handed, but happy to talk with you about it in terms of helping you figure out the amounts. It's more anecdotal than anything. It's not legal advice that we'd be giving you, but that certainly is a corollary undertaking that many people will do when they're doing their planning. Yeah, and here's our contact information. I have a couple of other I have a couple of other questions that didn't appear on that list, and I'm happy to go into, but I'd rather open it up now that we're at 7:30. If there's extra time at the end and I've answered the questions for the people that are here, I am happy to answer a few of these other questions for those of you out there that are listening on a recording.
Okay, thank you. Everybody start sending any questions now. We have a couple already. Number one, can you talk about the impact of moving states or countries?
Sure, that's a great question. So moving states, so every state in the United States has reciprocity with the other states, meaning that they must honor each other's documents. So long as documents are executed effectively in one state, they will be honored in another. So there's really not a requirement that one redo documents when they move to another state. That said, people often will reach out and ask, should we redo the documents? Often we will just take a look. We can't counsel about other states, but we will just take a look and see if there's any real divergent requirements. Often the Northeast is very similar in its requirements in terms of what the state's documents look like. And we do practice in both New Jersey, Connecticut, and New York. So if those are some of the surrounding states, we are happy to address that with you. In terms of moving to another country, most countries, we have a treaty in place that addresses how the documents would be handled. And usually there is reciprocity in terms of honoring, American wills in other countries. But we are happy to address that with you, get into the specifics about various countries in a gratis call.
Thank you. Another question, do you have experience with likely guardians being non-US based?
Yeah, that's very common. Obviously in New York, we have a lot of, international loved ones, in various ways, whether they're friends, family. So non-US persons can serve as guardians to children. Sometimes the bigger kind of issue to grapple with is the trust. If you set up a trust here and you have a US trustee, you want to make sure that you're not putting the assets in a position where they would become a foreign trust if an international loved one were to become the trustee. But these are actually issues that can be handled fairly easily if the documents are addressed properly. In other words, there can be brought on a co-trustee. The big issue around an international trustee is really just that the US court needs to establish and maintain jurisdiction over the trust, meaning that the US court has authority for the assets. So there are ways to manage this that, like I said, are not super complicated. But definitely with the guardians, that's a very easy thing to accommodate and something that I'm happy, we'd be happy to talk you through in an introductory call.
Thanks. Okay. Do we need to know who the guardian would be before coming to you, or if we haven't really settled on a guardian, can you talk us through how we might pick one from a few different alternatives?
Yes, absolutely. We are happy to spend some time, I'm happy to spend some time counseling with you about choice of guardians. I think that's probably the most important decision that we make. And I think often a very difficult one to think, if I wasn't raising my children, who else could do it? And for some people, lucky people, they have one person, it seems very obvious, but for many families, there's quite it's quite an inquiry. You've got potentially two different sides of the family to think about, and complexities around, how would the family feel, the ages of the children. A lot of times, when children are younger, I think parents can envision that children could move, but as children get older and are teenagers, often they are more attached to where they live, and it would be more of a difficult transition. So there are a number of factors, and like I said, age of the children, relationship with the loved ones, location of the loved ones, lots of things like that. And we're very happy. And we do certainly encounter situations where there are, super competent, loving, appropriate choices on both sides of the family, and people are just stuck. And that's something that we counsel pretty well around. We often advise the use of a letter as a supplement to a will. And that, wills usually do contain a succession. All you need is one guardian to effectively execute a will. But many people will have a succession, maybe 2 levels, first choice, second choice, in a will. And so that can allow a little bit of flexibility around choices that you could describe. You could use the letter to be a bit more descriptive, but make sure that you include a comprehensive list of the various options that could potentially serve, because none of us have a crystal ball. Hopefully none of this ever comes to pass, but circumstances certainly can vary if it ever were to do so. And maybe in a lot of ways, what people would like is that their loved ones would talk and sort out what would be the best choice for children. So that's something. We have some sample letters and some letters of intent and directives, things like that, that can help people kind of think that through, and also create more of a collaborative idea of the planning that they could share with their loved ones through a letter that would never need to be read unless it was ever needed. So certainly it's something that we spend quite a bit of time counseling around, is choice of guardians.
Thanks. Can you speak to various tax strategies with children, such as 529 plans or living trusts?
Absolutely. So the tax planning, well, let's see. So we talked a little bit about the estate tax situation, and there is another form of managing an estate that's called annual exemption gifting. And maybe some of you have heard this before, that there's a certain amount that you can gift every year, and that it passes tax free. So I'm just going to explain that to you. So that you can understand what that means, tax-free, like what tax would otherwise be applied, and how that might work with trusts and revocable living trusts, how those figure into maybe some aspects of tax planning. So the annual exemption gifting, basically right now, a person can give $17,000 a year to as many people as they want without any gift tax implications. So there is not a federal gift tax, nor is there a New York gift tax. So if you give over 17,000, you're not going to pay a tax. But what you will have to do is file a gift tax return. And earlier when I talked about the estate tax, these thresholds, the 6.5 I was talking about in New York, and the almost 13 million that is on the federal level, this includes all these thresholds over which you would then face an estate tax. These levels include not only what a person owns when they die, but also all the gifts they've given through their lifetime. The idea is that the government doesn't want to allow for people when they're 105 years old and they've got 5 days left to live, and they give all their assets away, after they have $50 million, and say, phew, we don't have any estate tax. So the government addresses that by saying it's not just what you own when you die, it's also what you gifted. So this annual exemption giving is basically, you can give up to $17,000 and not file the gift tax return. And in other words, not start chipping away at that exemption. Anything over $17,000 basically begins to accumulate and is part of what then would be considered your taxable estate, upon passing. So this strategy, the $17,000, can be made really good use of, in the sense that you can start gifting to your kids and chipping away at what is, maybe a legacy for you, and you can put it into a type of trust called a crummy trust. And we can talk more about that specific type of trust, but you obviously wouldn't want to be gifting it directly to your children, nor could you, but you certainly could gift it into a very specific type of trust that would hold it, say, until they're 40, till they're 35, ages that you would decide that it might be a time that they could make use of more wealth. Revocable living trusts aren't actually tax planning vehicles. Revocable living trusts are really designed to allow assets to pass without the necessity of any court involvement. When somebody has a will and they die, basically the will gets presented to court, a judge reviews it, and then says, okay, that looks good. Go out and do all the, all of the appointees go out and do the things that are directed in this will. if a person has a revocable living trust, I'm just going to go back to the package prices so you can see what these packages cost. There we go. So the revocable living trust package, that's $44.50. And so the benefit of this is that if you have your assets in a revocable living trust, it doesn't go through court. You have a succession of trustees. You yourself would be the trustee during your lifetime. Then you would have the next person after, if something were to happen to you, if you have a partner or a spouse, they might be the successive trustee. And then after that, the person that you'd want to manage assets for the kids. So when you have a revocable living trust in place, this simply just gets passed directly. The baton gets passed, no necessity for the court getting involved. Overwhelmingly, the basic package here is what we see, what we absolutely encourage people to do. These are the basics. This must be done. And as I mentioned, this last will and testament does include a testamentary trust, meaning there is a trust that's created. Those assets would just get moved into that trust during the court process. So that's the distinction there.
Thank you. If parents are partnered but not legally married, will that complicate things? And is there any documentation that would help in that case?
It doesn't complicate things, but it is even more of a reason to do planning. If a person is not legally married but partnered in New York is very antiquated, in my opinion, and not giving any recognition to the partner. So if you were to die, you have children together, you have a partner, all of your assets would pass to your children, nothing would go to your partner. So, and likewise with the incapacity documents, you can generally establish yourself, and we've all heard nightmare stories about people having to visit, their partner on visitation hours because they're not considered a true, they're not considered the primary point of care the way that, a spouse would be, and it passes then to the next of kin based on blood relations. So I would say it's that much more important to do your planning if you're non-married partners. And the planning is all the same. It's the same planning. It's just that much more important. And if one decided later to get married, the documents would not need to be redrafted or re-executed.
Thank you. That's a great question. How will courts know if I or we have a will?
Yeah, that's a great question. And that's the part that I really want to really, talk about when I mentioned, like, what is an estate plan? So an estate plan includes not just getting these wonderful tools in place, but also making sure that they would be accessible and that they would be utilized. Wills are not registered with the court. They are not held with the court. They are not registered there. They have found that more wills are lost when they're registered because it's county specific. So if people move and they had filed that New York does offer a service where you can file your will with the court, but that is just not an advisable thing to do. The courts are fairly disorganized, and filing the will upon someone's death is the most practical and common practice. So what does one do? And I think that's a really important question. What we usually recommend is that we do offer a full service where you can keep the documents with us if you wish. And in that case, well, in either case, or you take them home with you and you put them in a fireproof box somewhere very specific in your home, not in a safe deposit box, because then the loved ones have to know about the safe deposit box, and then they have to get authorization to get into it. So the two primary strategies are to leave it with a drafting attorney, or to put it someplace in your home in a fireproof box, and to let your loved ones know where it is. And what we usually suggest is that you send an email to at least one, hopefully two loved ones, and say, we did our planning, copy us on there. This is the attorney that we worked with. They've got electronic copies of everything, or they're holding our originals. And or we've put them in a fireproof box in the top of our closet. And then there's certain things that we might suggest that you share with them. And we could kind of talk about that, but to make a very practical plan so that your loved ones know that you have a will. And then the loved ones, of course, are the front line if, you know, something ever happens in a family, or, you know, for aging parents or for anything, it's the loved ones that know. And then if you have that email, you've sent out that email, they can easily search back, find the email, get the contact information, things like that, you know, and make sure. I mean, we stay involved. We are definitely a firm that, you know, we have longevity, that we have other attorneys that are working here. So we are a firm that will go on, and we would definitely be part of that process and conveying to loved ones, you know, some information about the planning.
Yeah. And that brings up a point that often comes up in these webinars, which is that not everybody knows, and we certainly didn't know, that it has to be the original will. You can't file a copy of the will. It has to be the original will. So you need to plan where you're going to keep that. And what I've heard is that if your house burns down and your will burns with it, you're out of luck. But if you're keeping your will at your attorney's office and their office burns down, they can
certify us to the, yep, that's exactly right. So that's the one advantage of keeping the will with the attorney, that if there's an act of God, whatever it is, and a will is destroyed, the attorney can certify as to what they call chain of custody. The attorney can say, this copy is the copy, you know, is exactly what they signed. They signed it. We scanned it into our system. We stored it in our will vault. And there it has stayed ever since. So we can vouch for the fact that this copy is exactly what they signed on this date. Whereas if a person takes it home with them, obviously lots of things could have happened and the court won't allow for the probate, which is what, you know, the process is called when a will is submitted. They will not allow the probate of a copy if the attorney didn't keep it. That's exactly right.
Mm-hmm. Thanks. Follow-up question on international issues. How do you handle guardians and trustees in foreign countries that don't speak English?
So usually what happens if a person, well, I guess, you know, the question is, if a person were to die here, can you repeat the question? Was it asking about if the guardians and trustees are international?
How do you handle guardians and trustees in foreign countries that don't speak English?
Yeah, I mean, usually that makes use of translation services, right? What happens is that there would be a process that would be undertaken in the US courts that would obviously be in English, and then a translation service would be provided there. And then it would usually go to the court if the children were going to transfer to another country as part of that appointment. It would go to the court in that country for validation. Like I said, it's governed by treaties, and it's usually, you know, fairly pro forma. I mean, I would say there's exceptions in certain countries, but the treaty does govern. And there would be obviously then English translation in the other country if there were, you know, English participants there too.
Thank you. I have a child with my ex. Without a trust, will my ex end up controlling the money that passes to my child if I die? And could an ex contest a will that has a different arrangement?
That's a great question, because we do work with a lot of separated and divorced parents, and, you know, and single parents by choice. But this pertaining to, you know, to families where there's, you know, two households. So, you know, I touched on this about the importance of, as a single parent, of, you know, getting your planning in place, because the trust becomes more of the focal point than the guardianship. I think, you know, two parents come in and say, oh, we travel a lot together, we're very worried about guardianship. You know, people get divorced. That's not really the biggest focal point anymore. Then it's more, how will my assets be made available for my child? And we get this question a lot. Will the other parent have access? So when you set up a trust, you name the trustee, right? That would be the person that, and this basic package has the trust in it. It's always important to have some form of a trust when you're doing planning for a minor child. You choose the trustee and you choose the directives for how you would want those assets to be managed for the benefit of a child. You know, we see a lot of parents who say, look, I'd want the other parent to basically make sure they were, you know, holding up their end of the deal. But I also want my trustee to know that if my kid was being deprived, or my child, and the other parent wasn't able to provide financially, that if there were sufficient resources in my trust, I'd want my trust to, you know, my trust to provide for the child. So those are the kinds of things that can be built into the trust. But without planning in place, the guardianship, like I said, you have to establish guardianship over the property for a child if there's no, and so the other parent is often the one that petitions to become the guardian of the property as the person who has guardianship of the child. Now, that said, the court is very strict about they become the co-signatories on those assets. And usually they won't allow a lot of distributions if it, if a child, they will ask the other parent, like, why aren't you paying for this first before they'll start allowing distributions out of these kinds of guardianship accounts. But that said, also it becomes, harder to access and maybe, limits the choices that are available for a child. And not only that, then those monies are going to issue to the child at 18. All of it becomes the child. So that can be a pretty bitter pill to envision as well. So I think as a single parent, I really always try to say it's even more important to do your planning.
Yes. Once we set up a trust, do we need to update the beneficiaries of all our financial accounts to become the trust? Once we set up a trust, do we need to update the beneficiaries on all of our financial accounts to become the trust? Does that make sense?
Yeah, that's a great question. Okay. So again, I just want to make the distinction here about the trust that's in the will versus the standalone revocable trust. Again, looking at this package here, we've got the revocable living trust package here, and then the will here that has the testamentary trust in it. So if you choose to go the basic route, you're not going to be moving assets. That trust is going to sit there and be available. And if it were ever needed, then those assets would be transferred at that time. But with the revocable trust, and as we were talking about, the benefit of that is that it doesn't go through the court process. Indeed, you do need to make sure that the assets indicate that you have a trust. And often it is through the beneficiary designation. That is a process that we walk you through. We give you very explicit instructions. We look at each one of your assets with you. You're going to fill out a very comprehensive but basic inventory of your assets, and we go through each one of them with you, give you a to-do list of what you need to do to make sure that that would be part of the trust estate if you were to do the revocable trust package. And yes, indeed, that it often does entail updating the beneficiary designations. Then we provide the exact language for that as well.
Okay. Once a will is filed with the court, how long does it take for that will to make its way through and for things to start getting settled?
That's a great question, and often one that will, is one of those weighing points, like, should we do the basic package or should we do the revocable trust package? What is that, if it doesn't go through probate, how much is that really saving us? So, and that's hard to say because different times, different circumstances. Right now, Kings County Surrogates Court is a mess. They have, the surrogate recently got fired, and it's just kind of a madhouse over there, if I'm being honest. So we are definitely seeing a pretty protracted experience of people going through probate in Kings County, upwards of 6 months. And we've had good luck. We've seen a few of them come through in 4 months, but, often closer to 6 months if there's complicated. I have an estate that's in there that people contested it, and it's been there since 2016. So, things can be really messy over there because people keep retiring, or, it's a messy court. But in New York County, for example, things move pretty smoothly, and usually we're seeing things completed within a few months.
Okay. I imagine that's pretty stressful for a lot of people. If if one part of a couple dies, one person in a couple dies, and it's a 2-income household, you're counting on things getting settled more quickly. And I'd imagine that's really stressful and a little scary. Is there anything to do to work around that? Is that where a trust would come in?
That's where the revocable trust comes in. That's what alleviates that issue, right? You have everything in a trust, and you never have to submit you don't have, the assets don't have to pass through the probate process.
Okay, we have a couple more minutes for questions if anybody has any more questions. Okay, here's one. if the assets we put into the trust change, do the packages include a reasonable number of updates? I guess the packages that you offer.
Yes. So the asset, the gift in the documents is generally fairly general, so that you don't have to update the documents themselves when you update assets. We will always be here to help you get the titling correct on new assets. But for example, if you set up a revocable trust and then 5 years later you buy a home, we're gonna remind you, but we're also going to give you a reference guide about, oh yeah, what do we do now? We're buying a home, we have a trust, what do we do? So you're going to want to name the trust on the, you're basically be putting yourselves as trustees on the deed rather than yourselves as individuals. And you do that in the closing process. So every time you acquire a new asset, you're gonna know, and you'll get, like I said, we give you a reference guide that has every kind of asset in it, and it's very specific to you about what you do. But yeah, that you'll look and you'll say, okay, we're opening a new investment account. What do we do here? But so you generally don't need to update the trust, for just the acquisition of new assets. That said, the way we handle updates of all documents is usually just to bill hourly for it. I mean, quite honestly, these are documents that have been created. They're Word documents. They usually don't require a lot of manipulation to make changes. It's usually, under an hour to do those kinds of updates.
Is there any inconvenience to having an RLT, for example, during financial transactions, buying property, etc., if in best case scenario, we live 50 plus years without either of us dying?
So RLT stands for Revocable Living Trust. And so what the question is does that encumber, transactions? And to which I would say no. I mean, people often ask that about real estate. Oh, what happens if we try to sell it out of our trust? Nothing. It's the same thing. You're just going to sign everything in your name with, the letters TTE or as trustee or, something like that after your signature. And in terms of opening accounts, somebody asked the question earlier about the beneficiary designations. Sometimes people will use beneficiary designations to ensure assets would be in the trust if something were to happen to them. And sometimes people will retitle their assets so that the account itself will say, Laura Fischer, trustee. But none of that, these revocable living trusts are considered disregarded entities, meaning that they have, for example, like if you were to move your home into it and you had an existing mortgage on it, it's statutorily protected that you don't have to put the bank on notice. You don't have to change the mortgage. You don't have to do any of that. It's a disregarded entity. It basically mirrors the, your ownership as an individual, with its primary benefit being what we were discussing, then it doesn't have to go through a court process. So it is statutorily protected as a disregarded entity that it really shouldn't encumber any of the transactions.
Okay, we have 1 minute. You take one quick question, and here's one. How much of your practice addresses tax planning beyond just wills and estates?
I mean, we have a full service practice and we work with, all different level of assets. So I guess maybe the question is what percentage is, so do we do irrevocable trust? We do quite a bit of it. I mean, and the complexity of the types of irrevocable trust just kind of, are we doing a lot of, charitable remainder trusts? Not so much of those. Do we do a lot of irrevocable life insurance trusts? Yes, very many. So it really depends, on the type of asset. If income tax, if there are income tax implications, we will definitely make sure that we bring an accountant in to make sure that, there's nothing with regards to how they're filing their income taxes. Assemble the right team so that we make sure, but usually when we're talking about, estate tax planning, it's something that the attorney will handle. So we are definitely a full service firm and can handle all level of assets.
All right, thank you. It's 8 o'clock and I don't see any more questions. So thank you so much for everybody who sent in questions. They were great questions, and I'm sure you weren't the only person who had that question. So you helped a lot of people. We're going to send the recording out either tomorrow or Monday, so look for that. And I'm going to send out an email in the next few days also asking for your feedback on the workshop. So please send us your thoughts. So again, Laura, thank you so much.
Thank you so much for having me here. And I've really enjoyed, interfacing with the group and agree. The questions were excellent. And I hope that if you have others that weren't answered, you give us a call or reach out with an email. I'm happy to give you some more information. Thanks for having me.
Thank you. Have a great night, everyone.
Bye, everybody.
Bye.